Hello, good morning friends. Good morning. Namaste, Namaskara, Namaskaram, Namaskar, Assalamu alaikum, Vanakkam. Friends, as part of today's video lecture series, I would like to explain the concept of constitutional validity of death penalty in India. This class is a live class. It is exclusively available on Unacademy Judiciary platform. Okay, friends, this is an important concept for all junior civil judge examination aspirants. This kind of questions may be asked in written examination or in essay writing also. Okay, our today's concept is the constitutional validity of death penalty in India. Friends, let us have a quick look on various aspects of death penalty in India. Friends, if you go through sections 53 to sections 53 to 75, sections 52 to 75 of IPC are related to punishments. Okay, punishments. A separate chapter in Indian Penal Code is exclusively related to various kinds of punishments. Friends, if you see section 53 of IPC, section 53 of IPC speaks that section 53 of IPC, okay, it prescribes 5 kinds of punishments. 5 kinds of punishments. Okay, let us see those 5. The first is capital punishment, that is death penalty. Death penalty. Okay. The second one is life imprisonment. Life imprisonment. The third one is imprisonment other than life. Okay, imprisonment, simple imprisonment and a rigorous imprisonment. Okay, next the fourth one is forfeiture of property. The last one is fine. Friends, thus there are 5 kinds of punishments enumerated under section 53 of IPC. The 5 punishments are death penalty, life imprisonment, imprisonment other than life, that means simple imprisonment and rigorous imprisonment, forfeiture of the property and fine. Okay, the highest punishment is the death penalty, friends. The highest punishment is death penalty. The lowest punishment is fine, friends. The lowest punishment is fine, especially under section 510 of IPC prescribes lowest punishment. Okay, lowest punishment. If you go through section 510 of IPC, you can find that There is a lowest punishment, misconduct in public place, misconduct in public by a drunken person. Here friends, the punishment of fine is lowest for this offense, that is imprisonment for 24 hours, okay, 24 hours imprisonment, or 10 rupees fine, or both. This is the lowest punishment, friends. Now let us see the highest punishment. The highest punishment is the death penalty. The highest punishment is capital punishment. Here it's the duty of every state to protect the interests of the public, to control the law and order in the state. Therefore, it has to impose various punishments. Later on, several arguments have been conducted with regard to whether death penalty is a suitable punishment for any person, whether it should be abolished. After various discussions, then British government has introduced death penalty as one of the severe punishments, the maximum punishments under IPC. Okay, friends, if we go through the same, the concept of death penalty, for the purpose of these punishment is for administration of justice. Okay, administration of justice. This is the administration of justice is the ultimate object of the state. Due to the same, various kinds of punishments are imposed by the state in case of a person who breaks any peace in the society. Okay, now friends, let us see various concepts of these punishments. Okay, when the death penalty can be imposed. Okay, let us see when death penalty can be imposed in IPC as well as in other legislations. Okay, let us see this concept, friends. Death penalty. Okay, when death penalty or capital punishment can be imposed. First, part 1. These are the death penalty under Indian Penal Code. Okay, Indian Penal Code, Indian Penal Code 1860. Okay, friends, in association with India's largest education platform, Unacademy, I am teaching the class on the constitutional validity of death penalty in India. It is a live session. It is very useful for the judiciary examination aspirants as well as law students and junior advocates. Okay. Now let us see various sections of law in which the death penalty can be imposed under Indian Penal Code 1860. Friends, death penalty is the maximum punishment. It is the maximum punishment that can be imposed for any offense. Okay, in any country. Okay, it is the maximum punishment in any country. If you take any democratic country or autocratic country, Here the death penalty is the maximum punishment. Okay, fine is the minimum punishment. Now let us see under Indian Penal Code when the death penalty can be imposed. There are 15 instances, friends. There are 15 instances. Under these 15 instances, the state can impose the death penalty upon the offenders. Now let us see one by one. Let us see one by one. The first one. The first one is waging war against the government. Okay, waging war against state. The second one, attempting to wage a war against state. The third one, abatement to wage a war against the government. Friends, these three come under the purview of section 121. According to section 121 of IPC, the waging war against the state, attempting to wage a war against the state, abatement to wage a war against the state can be punishable with death penalty. See the contents of this section, friends. The person is waging war, okay. The person who attempts, here there are different stages involved in committal of a particular offense. Among those, first, intention, preparation, attempt and accomplishment. These are the four stages. Here waging war against the state is the fourth stage, okay. Attempting to wage the war against the state is intention, preparation, then attempt. Even if a person who is attempting to wage the war can also be punished with the maximum punishment, that is death penalty under section 121 of IPC. Even the person who abets the other person or other persons to wage war against the state can also be punishable with death penalty under section 121 of IPC. There are a lot of recommendations and various people, especially the people who are fighting against this one, waging section 121, have been agitating that section 121 has to be abolished. There are divergent opinions with regard to this section on the minds of the intellectual. Okay, according to them, according to the intellectual group, section 121 is nothing but a vendetta on the common man. It's simply curbing of the voice from the people. Whenever a person shows any faults on the state's side, on the government side, then the government can utilize this section and it can it can easily take the cognizance related to an offence under section 121. Simply he can be imprisoned and he can be undergone to the death penalty. Therefore, there are divergent opinions with regard to this one, especially section 121. Okay, the intellectuals have been demanding that death penalty has to be completely abolished. More particularly, the death penalty under section 121 has to be completely abolished. This is the version of few intellectuals, but the state has been filing number of cases against the persons who are the voice of the people under section 121, and the state has been imprisoned various civil rights activists under section 121. Okay, it is quite common in all the governments. It's quite common, any kind of the government. Okay, thus, friends, waging the war, attempting to wage the war, abetment to wage the war against the state is imprisoned with death penalty. That is the maximum punishment prescribed under IPC. Thus, these are the first three instances. Let us see the fourth instance. The fourth instance is abetment of mutiny actually committed. Okay. Abetment of mutiny okay actually committed. Friends, if you go through friends, if you go through section 132 of IPC, section 132 of IPC, here if you go through section 132, abetment of a mutiny is if it is actually committed. Friends, it is not related to mutiny or attempting. It is related to abatement, friends. Abatement of the mutiny. Here, if you go through section 132 of Indian Penal Code, whoever abets the committing of mutiny by an officer, soldier, sailor, or airman in the army, navy, or air force of the government of India shall, if mutiny be committed, the words actually committed, okay, committed in consequence of that abatement, be punished with death or with imprisonment for life or imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Thus, any officer of the army, navy, or air force abets his troop to commit the mutiny, then it shall be punishable with death penalty, a maximum punishment of death penalty. Here the abettor, any officer of the navy, air force, okay, army, if he abets his troop, perjury resulting in conviction and death of an innocent person, okay, see section 194. Perjury resulting in the conviction and death an innocent person. Section 194. Friends, giving the false evidence. Giving of such false evidence is resulting in conviction of a person, especially the innocent person. Thereafter, that innocent person is punished with the death penalty. It is here under section 194, if any person gives a false evidence before the court of law, due to his false evidence, if an innocent person is convicted and he is punished with the death penalty, if it causes the death of such innocent person, then the person who has given the false evidence can be subjected to death penalty under section 194 of IPC. It is the fifth section, friends, wherein the death penalty can be imposed on a person. Next, the sixth one is threatening or inducing any person to give false evidence resulting in the conviction and death of an innocent person. Friends, this one is discussed under section 195A. Okay. Threatening a witness, inducing a witness or any other person to give the false evidence before the court of law, that results in the conviction and death penalty to innocent person. The first one is giving the false evidence. The second one is threatening and inducing another person to give the false evidence about an innocent person, that may be resulted in conviction of that innocent person and death of the innocent person. That is also punishable with death penalty in India, according to section 195A of IPC. Friends, the next one is, the seventh one is murder. Okay, murder, section 302. If a person commits murder upon the another person, which is not amounting to culpable homicide, then he will be punished with death penalty under section 302 of IPC. Okay, friends. The next one is, this is the seventh one. Now let us see the eighth one. Okay. Next, the eighth one, abatement of suicide by minor. Abatement of suicide by a minor insane or intoxicated. okay, is punishable with death penalty according to section 305 of IPC. If a person abets a minor to commit the suicide, if a person abets an insane person to commit the suicide, if a person abets an intoxicated person to commit the suicide, shall be punishable with death penalty under section 305 of IPC. Next offense, the ninth one, attempted murder by a serving life convict. Okay, a serving life convict. Attempted murder a serving life convicted. Okay, section 307(2). Section 307 subsection 2. Okay, already the person is life convict and he has attempted to commit a murder upon the other person, then he will be punished with death penalty under section 307(2) of IPC. Next, the 10th one is kidnapping for ransom. Kidnapping for ransom is also punishable with death penalty according to section 364A of IPC. Okay, sections 364A of IPC. Here this concept is related to kidnapping the children below the age of 18 years and kidnapping a woman, okay, can be imprisoned with life imprisonment, death penalty according to section 364A of IPC, friends. Next, rape and injury which causes death or leaves the woman in a persistent vegetative state. Okay, a persistent vegetative state. Now, according to section 376A, if a person commits rape upon a woman and causes the injury, that injury causes the death of the victim woman, or that injury leaves the woman in coma, in a persistent vegetative state, under those circumstances, such offender will be punished with the death penalty under section 376A of IPC. Okay, the similar sections, the similar concept is also well discussed in various punishments for rape, especially section 376AB, where rape on a girl below 12 years of age according to next. Let me write the section of law later. Now the gang rape on a girl below 12 years of age. Thereafter, the 14th one is a repeat offenders in the context of rape shall also be liable with death penalty, friends. Let us see the section of law. This is enumerated under section 376A(b). It is newly inserted section, friends. As per the Criminal Laws Amendment Act 2018, this section was introduced, okay, in 2018. It is also introduced in the year 2018, okay. Criminal Law Amendment, Criminal Laws Amendment Act 2018. Through this one, these two section 376D B is also imposes the death penalty upon the offender. Then the 14th one, repeat offenders in the context of rape. The persons who repetitively commits the rape upon the woman shall also be liable with death penalty under section 376E of IPC. Okay. Here 1, 2, 3, 4. These four are related to the death penalty in case of rape in India, friends. Okay. The 15th one is dacoity with murder. Dacoity with murder as enumerated under section 396. These are the 15 instances wherein the death penalty can be imposed upon the offenders, friends, in IPC. There are several other legislations also wherein the death penalty is also imposed. Friends, if we see this one under IPC, there are 15 instances. Under these 15 instances, the death penalty can be imposed upon the accused person, the convicted persons. Here, these 7 plus here 8, totally 15 instances as per the latest amendment to the criminal laws. Now, friends, let us see what are the other legislations wherein the death penalty can be imposed upon the persons. Okay. In Air Force Act 1950, friends, if you go through sections 34, 37 and 38(1) of Indian Air Force Act, here this is part 2. Death penalty under other legislations. Or other laws. Death penalty under other laws other than IPC. The second one, as per Arms Act 1959, okay. The Arms Act 1959, okay. Section 27(3). Now it was repealed, friends. It was repealed. The third one, Andhra Pradesh Control of Organized Crime Act, AP Control of Organized Crime Act 2001. Here section 3 subsection 1 clause 1. Under this one, a person can be punished with death penalty. Then the Assam Rifles Act, Assam Rifles Act 2006. Here according to sections 21, okay, 21, 24, thereafter section 25 subsection 1 clause A, okay, and section 55. These sections shows the death penalty to the victims under Assam Rifles Act 2006. Thereafter, Bombay Prohibition Gujarat Amendment Act 2009, okay. The Bombay Prohibition within the brackets Gujarat Amendment Act 2009, section 65A subsection 2 also imposes the death penalty upon a person. Thereafter, the Border Security Force Act, Border Security Force Act, the Border Security Force Act 1969, especially sections 14, 17, 18, subsection 1, subsection 1 clause A, okay, then and section 46. These are related to the death penalty, friends. According to these sections, a person can be imposed with the death penalty. The seventh one is Coast Guards Act, okay, the Coast Guards Act 1978, according to sections 17 and 19, a person can be imposed with the death penalty. Then the Commission of Sati Prevention Act, according to this, okay, especially according to section 4 subsection 1, a person can be imposed with the death penalty. Then the Defense of India Act, okay, Defense of India Act 1971, especially sections 5, section 5. Then Explosive Substances Act, the Explosive Substances Act 1908, especially under section 3B. Okay. Then the Indo-Tibetan Border Police Act, Border Police Force Act. Okay. Police Force Act 1992. Under this one, sections 16, 19, 20, subsection 1, class A and 49. According to this, a death penalty can be imposed. Then the 12th one, Narcotics, Drugs and Psychotropic Substances Act 1985. Okay, according to section 31A subsection 1. The 13th one, according to Navy Act 1957, especially according to, there are various sections, section 34, 35, 36, 37, 38, 39, 43, okay, 44, then 49 subsection 2 class A, and section 56 subsection 2 and section 59. It is also a jumbo. It comprises of a death penalty. It is also a jumbo act which prescribes the death penalty to the accused. Here the SCs and STs, prevention of atrocities act, okay, prevention of atrocities act 1989. Here section 3 subsection 2 clause 1 prescribes okay, the death penalty. Then the 15th one, the suppression of unlawful activities, the suppression of unlawful activities, the suppression of unlawful acts, okay, the suppression of unlawful acts against safety of maritime navigation and fixed platforms and Continental Shelf Act. Continental Shelf Act 2002, especially sections 3 subsection 1 clause 1. Then the Unlawful Activities Prevention Act, the Unlawful Activities Prevention Act 1967, especially sections 10 B1 and section 16 1A imposes the death penalty. Friends, these were the major these were the major laws. There are some other laws also, especially the Petroleum and Mineral Pipeline Acquisition of Rights of User in Land 1962. Here section 15 subsection 4 also imposes a death penalty. Then the Karnataka Control of Organized Crime Act 2000, here section 3 subsection 1 also imposes the death penalty. The Maharashtra Control of Organized Crime Act 1999 also imposes the death penalty under section 3 subsection 1. Here these are the Geneva Convention Act 1960, especially section 3 also imposes the death penalty. Thus there are various laws, friends, there are various laws. These impose death penalty upon the victim, upon the accused persons. Okay, now let us see the few important points related to the death penalty and its constitutional validity. Okay, friends, now whenever a death penalty is given, section 354 subsection C of CRPC speaks that whenever a death penalty is imposed, whenever a death penalty is given by the court, then the special regions, whenever there is a death penalty, special reasons for giving such death penalty has to be or should be recorded. Should be recorded, friends. Should be recorded. Then section 366 of CRPC. Section 366 of CRPC. Just go through this one. According to section 366 of CRPC, when the Sessions Court awards the death sentence, it has to submit the case to the High Court for confirmation as per section 366. Okay, whenever Sessions Court awards death penalty, okay, it has to submit the case to the High Court for confirmation. Friends, if you go through some other sections which are relevant to the concept of death penalty, section 416 of CRPC, section 416 of CRPC. If you go through section 416 of CRPC, friends, whenever death penalty is given to a pregnant woman, okay, whenever a death penalty is given to the pregnant woman, then The High Court shall order the postponement. High Court shall order for postponement. Okay. Postponement of execution of death sentence. It is very clearly stated under section 416 of CRPC. Then section 235, section 235 subsection 2 of CRPC, okay, is related to when death sentence is given to a person, it is mandatory for the court to hear the accused on the question of sentence before giving it. Okay, before giving death sentence, court must hear the version of the accused. Thereafter, friends, sections 302 of IPC speaks about death penalty has been considered constitutionally valid by the Supreme Court of India, okay, saying that there is no inconsistency between Article 21 of Indian Constitution in the case of which is held in the case Jagmohan Singh versus State of UP, State of Uttar Pradesh. Okay, in this case, sorry, in this case, the Supreme Court held that death penalty is constitutionally valid. Okay, it was stated under this case in Jagmohan Singh versus State of Uttar Pradesh. Okay, in this case, friends, in this case, the Supreme Court held that it is not violative of Article 21. It is constitutionally valid. It is constitutionally valid. Then let us see few important case laws with regard to this one. Let us see few important case laws with regard to this one. In Bachchan Singh versus State of Punjab, which was reported in 1980, the Supreme Court held that death penalty can be imposed. Death penalty can be imposed only in rarest of rare cases. Okay, the rarest of rare cases doctrine was first imposed in Bachchan Singh versus State of Punjab, but the court did not struck down the capital punishment in either of these cases. In Jagmohan Singh versus State of Uttar Pradesh, the Supreme Court held that death penalty is constitutionally valid. In Bachchan Singh versus State of Punjab's case, the Supreme Court held that death penalty is not an automatic punishment. The death penalty can be imposed only in rarest of rare cases. The doctrine of rarest of rare cases was introduced in Bachchan Singh versus State of Punjab's case, friends. Okay, this is about the concept of death penalty, friends. This is about the concept of death penalty. If we go through various other sections, friends, of IPC, CRPC, we can find several things. In a case reported in Machi Singh versus State of Punjab, it is laid down that the broad outlines of the circumstances when death sentence should be imposed. Justice Tucker, speaking for the court, held that 5 categories of the cases may be regarded as rarest of rare cases deserving extreme penalty. According to Justice Tucker, firstly, these have to be considered as per Machi Singh versus State of Punjab's case. According to Machi Singh versus State of Punjab, Machi Singh versus State of Punjab, Justice Tucker, Honorable Justice Tucker, held that under these 5 categories of the cases, death penalty can be imposed. Here, the concept of rarest of rare cases is well discussed in this case. Okay, what are the rarest of rare cases? It should be considered based on these five principles. The first one is manner of commission of offence. Manner of that is manner of commission of the murder or offence. Okay. The second one, the motive for commission of that offence. Motive. The third one is antisocial or socially abhorrent nature of the crime. Antisocial nature of the crime. Then the fourth one, magnitude of the crime. Then the fifth one, personality of the victim. Okay. Personality of victim of murder. Thus, in Machi Singh versus State of Punjab, friends, in this case, Honorable Justice Thakkar ji has given 5 principles which explain about the concept of rarest of rare cases, friends. In Dina versus Union of India, the Supreme Court of India held that the mode of execution by hanging is fair, just and reasonable procedure. Okay, hanging is just, reasonable and fair is well stated, and it is constitutionally valid according to Article 21 of Indian Constitution. It is held in Dina versus Union of India's case. In Dina versus Union of India, in this case, hanging is constitutionally valid. It is fair, just and constitutionally valid, is stated in Dina versus Union of India. In Sher Singh versus State of Punjab, okay, in Sher Singh versus State of Punjab, death sentence is constitutionally valid. It was held in Sher Singh versus State of Punjab. Death sentence is constitutionally valid. Thereafter, in Mittu versus State of Punjab, in Mittu versus State of Punjab, in this case, Section 303 of IPC was struck down. Okay. It is violative of Article 14 and 21 of Constitution. It was held that. Okay, except Section 303. Section 303 is now completely struck down in Mittu versus State of Punjab's case. In all other cases, in Machi Singh cases, in Jagmohan Singh's case, in Bachchan Singh's case, in Sher Singh's case, in Dina versus Union of India's case, death penalty is upheld by the Supreme Court as constitutionally valid, friends. It is upheld by the court as constitutionally valid. Friends, if you go through various data, if you go through the data of the Law Commission of India report number 262 on death penalty dated August 2015, especially in page number 188 and 189, you can find the mercy petitions decided by the presidents of India, number of mercy petitions accepted by various presidents of India, number of mercy petitions rejected by India. Dr. Babu Rajendra Prasad, the first president of India, has accepted 180 mercy petitions and rejected only one mercy petition. Here, Gnani Jail Singh, ex-president Gnani Jail Singh, has accepted 2 mercy petitions and rejected 30 mercy petitions. Sri R. Venkatraman Garu has accepted 5 mercy petitions and rejected 45 mercy petitions. Dr. Shankar Dayal Sharma Garu has rejected 18 mercy petitions. He has never accepted any mercy petition. Okay. Srimati Pratibha Devi Singh Patil, while her tenure as President of India, accepted 34 mercy petitions and rejected 5 mercy petitions. Okay, Sri Pranab Mukherjee Garu have accepted 2 mercy petitions and rejected 31 mercy petitions. Highest is the first President of India, Dr. Babu Rajendra Prasad Garu, have accepted 180 mercy petitions and rejected only 1. Thus, until 2005, there are 306 mercy petitions have been accepted by our presidents. 131 mercy petitions have been rejected. Thus, totally 437 mercy petitions have been brought before the presidents. Now, this is the constitutional validity of the death penalty in India, friends. We have discussed every nook and corner with relation to the concept of death penalty, the concept of death penalty under Indian Penal Code, then the death penalty under other legislations, thereafter the relevant provisions of CRPC with relation to the death penalty, as well as the various cases. Now friends, in association with India's largest education platform Unacademy, I have been teaching the law classes, the live law classes in Unacademy Judiciary app as well as in YouTube live session in Unacademy Judiciary channel. Here you can use the code Subhan Sir, SUBHAN SIR, in order to avoid 10% of offer in the subscription fee. The expert team of Unacademy Judiciary with top educators have been conducting the free classes exclusively on Unacademy Judiciary app, Unacademy Learners app, which is exclusively dealing with various concepts of law, like it covers the criminal laws, civil laws, and the family laws and local laws of your respective states as per the syllabus of the junior civil judge examinations. Here it is entirely different from the traditional YouTube teaching. Here under Unacademy app, you can have live interaction with your teachers. You can attend the live classes, you can participate in the live chat, and you can get your doubts clarified during the live session itself. There are several options like conducting the polls to the learners, and the plus subscribers can directly talk with the educators and they can get the doubts clarified during the live session itself. And notifications, you will never miss any class of your favorite teacher or of your favorite subject of law. You can download the lecture notes of your teachers through PDF form directly from Unacademy app. Here you can watch these live classes of Unacademy at any time and anywhere. These are the benefits, friends. Okay, you can get the plus subscription access. You can get the classes from India's best educators. You will have interactive live classes, live tests, live quizzes, and structured courses and PDF notes also. Okay, these are the special offers, friends. If you buy 12 months of subscription, you will get 1 month subscription free. If you buy 18 months of subscription, you will get 2 months of subscription free. If you buy 24 months, you will get 4 months of subscription free. The offer is ending soon, friends. Now block your calendar. The expert team of Unacademy Judiciary have been conducting the detailed batch courses, and they have been providing everything the learners need to crack the judiciary examinations. Okay, there are elite batches, target batches, acceleration batches, comprehensive batches, foundation batches, and target batches. Every batch has been conducting the classes. There are mock tests also. T20 daily mock tests have been conducted on the core subjects of IPC, CRPC, Evidence Act from every Monday to Friday in between 9 AM to 9:30 AM. Okay. These are the subscription plans, friends. Subscription plan starts from 1 month to 24 months. Now there are some news that the subscription plan will be changed. There will be a hike in subscription amount. Therefore, you can subscribe the Unacademy channel now. Okay, you can use the code SUBHAN SIR Subhan Sir in order to avoid 10% of offer in the subscription fee. Okay, subscribe Unacademy Judiciary YouTube channel. Okay, you can use the Telegram channel of Unacademy. Okay, Unacademy Judiciary Telegram channel. Friends, I think you understood today's concept. It is very helpful for your written examination, especially for the criminal laws paper as well as for essay writing paper. I think you understood this concept. Thank you for watching this class.